Mr. Dhanendra Kumar, former Chairman, Competition Commission of India. Mr. Kumar, delighted to have you with us on the panel. How does the new bill empower the Competition Commission of India? Because what we when we look at the report, we understand that the CCI is set to gain the more, perhaps it's been afforded abilities of different kinds in different aspects. So if you could help us and our viewers understand about the manner in which the CCI is set to get empowered once it becomes a law.
Thank you. First of all, thanks for the opportunity given to me today. Let me say that it is the first substantive amendment in the competition law after the enforcement began in 2009.
Right.
The enforcement actually began in May 2009 after the commission was fully constituted and an appellate tribunal was put in position.
Yes.
Now, after that, it was noticed that the shape of the market has changed considerably with the advent of new technology and with digitization, and the existing act was not in a position to capture everything because of various factors. There were situations when companies were becoming dominant by accumulation of data and by network effect and so on, and many things were not captured by the various provisions. So this new bill, which has been enacted now, which was enacted, the committee was constituted, Competition Law Review Committee, under the chairmanship of then Secretary Injayati Srinivas in 2018. And on their recommendations, a bill was drafted, submitted to the Parliament, and it was sent to the Standing Committee, and we have Mr. Amar Patnaik, a distinguished member of that committee, with us today. And on the basis of those recommendations, the government thereafter sent its new bill, and it has been passed by the Lok Sabha on 29th March and the Rajya Sabha on the yesterday on the 3rd.
3rd of April,
now,
yes.
the major amendments, let me quickly roll out, which would show that it would plug in many loopholes. Just for example, the earlier bill had this problem that in the digital platform these days, the entities, they grow dominant very rapidly. And to give you an example, that Facebook had acquired WhatsApp in 2014. And at that time, the assets and turnover of WhatsApp was, I would say, minuscule in proportion to the amount by which it was acquired. It was acquired for $18 billion in 2014, while the actual turnover at that time of WhatsApp would have been a few $million dollars. Now, they had an eye on the potential and the technology and data it would bring in. So, and it has really benefited them. So it has been captured now in the new amendment that deal value threshold above 2,000 crores. Now, if there is any deal, it would have to be mandatorily reported to the Competition Commission, who would look into it, the anti-competitive aspects and so on. It's something not new. It exists similarly in USA and so on. Now, settlement and commitment is something, again, which is existing in many jurisdictions, and it's very, very important that we should not only focus on imposing penalties, but the focus should be on bringing in market corrections, which is the main objective of the existence of the CCI. Now, the penalties which have been imposed so far, about 17,000 crores worth of penalties, the actual recovery has not been even 1%. Now, with this commitment and settlement thing being brought in, it would be possible for the companies to enter into a commitment in the beginning if the matter has not been, if the DG has not submitted its report, and settlement if DG has submitted his report, but CCI has not yet passed the order.
Okay.
So in either of the situation, the companies can enter into a settlement kind of a thing. And it is not, again, something unusual. It happens in taxation, it happens in SEBI, Vivad Se Vishwas and all that. So all those things are there right now. And this would help in releasing energy and the time and resources of the companies, as also the CCI. So again, and the third thing, which is in my view very important, is the global turnover. Now, in the digital economy, again, it is all interconnected, the digital economy.
Absolutely.
And what is happening somewhere, it would have impact elsewhere also. So to make it a global turnover, although it may look a bit punitive or deterrent, but yes, this would also for the multinationals, and it's not only the digital enterprises, but also automobile companies like, for example, Toyota, Hyundai, and so on. They have operations all over the world.
Kumar, coming back to you again, it proposes to cut down the timeline for approval of combinations to 150 days from 210 days.
Yes.
Were there apprehensions, or will there be apprehensions within the CCI, which already claims to be an understaffed commission? Does it add to their burden?
Well, let me first of all mention that when we initiated the combination review process in 2011, the enforcement of antitrust cases had started in 2009 May, as I said. Review of combinations started in 2011. Now, we had assured the industry at that time that we'll try to clear 95% plus cases within a period of 30 days. And I must say, to the credit of Competition Commission, that they have adhered to it, and almost 95-96% cases are cleared within that time period. Only a few cases go beyond that, and the limit of 210 days, which you mentioned, has also been strictly adhered to in those cases. I don't think there would be any problem at all in adhering to the 150 days limit. In any case, this is to give an assurance to the concerned parties that it will be cleared. There is also a provision there that CCI has to make a prima facie view within 30 calendar days, not 30 working days. And if it is not given out, then it would be deemed to be clear.
Yes.
So overall, the emphasis is on speed and ease of doing business. But just one more minute, since you mentioned about the global turnover part, that this could be a matter of concern. Let me tell you that it is just the outer limit. CCI has to decide based on the facts of the case, and there are attenuating circumstances, there are mitigating circumstances. It could be, it has happened in the past, it could be 0.1%, it could be 10%, it could be 0.01%. So depending on the situation, circumstances, it could be low also. The global turnover need not be taken as the benchmark. It is the outer limit. So I don't think that the company should feel frightened of this limit, and it will not be generally the matter that, and by the way, in global arena also, many jurisdictions in advanced countries, they also have similar limits.
Mr. Kumar, time allows me to take up quick remarks from you, concluding remarks. Now, the next step is how effectively it's implemented. How geared up is the CCI to incorporate these changes? Because a lot of onus lies now on the Competition Commission of India to make these changes into a reality.
Absolutely, you said it. Let me correct technically, rules are made by the government, that is the Ministry of Corporate Affairs. Regulations are framed by the CCI.
Commission, CCI.
Yes.
And CCI would definitely frame the rules. Wherever necessary, it will put them in public domain to invite comments. Right now, there is a little problem because chairman's post is vacant, but I'm sure it's going to be filled up soon. But CCI is working, and they should be making the regulations soon. Altogether, I think the picture is very clear what needs to be done. Everyone knows about it. Industry also, and again, I could possibly take a moment to compliment most sincerely the committee, Mr. Patnaik and his colleagues. They have done a brilliant job over a short period of time, within about 3 months or so.
Yes.
Heard everyone, all the stakeholders, and they have brought in all the perspectives in the matter. And I feel everyone knows what is to be done, and I am looking forward to very smooth implementation of the Act going forward now.